5 seconds to go. Start. He has also submitted that the trial court has not properly considered the evidence on record and has committed error in framing issues and has ultimately dismissed the suit of the plaintiff. He supported the judgment and decree of the First Appellate Court and had submitted that the findings of the fact recorded by the First Appellate Court is proper and valid, and this being second appeal, this court may not disturb the findings of fact which has been recorded by the First Appellate Court, which is based on the oral and documentary evidence. He has also submitted that though the attesting witness to the will has been examined, but the scribe of the will is not examined to substantiate that there was a legal will executed by the deceased. He has submitted that the present appeal may be dismissed. In rejoinder, Ms. Dhara Shah, learned advocate for the appellant, had submitted that the plaintiff has failed to establish the fact that the properties were of joint family properties. She has also submitted that the plaintiff, being son, was not residing with father and was residing with his wife at his father-in-law's house since 1950. This fact, according to her, is relevant, which has not been considered by the First Appellate Court. She has also submitted that the societal approach of the deceased, treating his son as of non existence for all purposes, is a relevant factor which is not properly considered by the First Appellate Court. She has submitted that there is no legal need that there should be registration of the will in every case. According to her submissions, there is always no necessity of giving entire description of the properties of the deceased. She has further submitted that the First Appellate Court has failed to consider the legal aspect regarding to the will and has committed serious error of facts, and therefore this court, being Second Appellate Court, can reappreciate the evidence on record. She has prayed to allow the present appeal. In the case of Narinder Singh Rao versus AVM Mahinder Singh Rao and others, Supra, the Apex Court has upheld the observations made by the High Court of Punjab and Haryana, which is as follows. It is pertinent to note as to how the High Court has decided the second appeal, and for that purpose, let us look at the findings which are as under. The ultimate findings arrived at by the court below are to the effect that the writing executed by Rao Gujarat Singh, which stated that upon death of himself or his wife, the suit property would be inherited by the survivor, was neither in the nature of a will nor in the nature of transfer of the property, because the said writing was neither registered as required under the provisions of the Indian Registration Act 1908, nor was attested by two witnesses as it should have been done had it been a will. Thus, the writing executed by Rao Gujarat Singh in the eyes of law was only a piece of paper having no legal effect. Stop.